Tutor, and in today's tutorial happens to be the continuation of the course CSS211 as a course for um, social science, 200 level first semester, precisely criminology, the Department of Criminology, and basically today we're going to conclude with the course on the formulation stage actually, and I will take some other course as we continue the classes. With this being said, let's hop straight into it. Okay. So we have CSS 211. Okay. CSS 211. And we're talking about the concept of law. The concept of law. Okay. Every society tries to ensure, it is the responsibility of every society. Just a moment, I'm trying to adjust my. All right, it is the responsibility of every society to ensure orderliness and orderly way of life for each, all right, of its members. It tries to adopt a set of rules to control and limit the actions of individuals. We're talking about the concept of law. Okay? And as we just established, that every society ensures, endeavors, and orderly way of life. Okay? Orderly way of life for its members and tries to adopt a set of rules to control and limit the action of individuals. Basically, this is what law is all about. A state, a group, a society, an organization, a gathering that involves one or two persons, there has to be rules and regulation to limit behaviors. All right, certain things has to be taken care of. Certain behavior has to be put in check. Relationship and communication. All right, and basically this set of rules, this body of regulation is what we refer to as law. All right, so let's take this down. Every society ensures orderly way of life. Okay, it tries to adopt a set of rules to control, adopts set of rules to control and limit individuals. Okay, are we together? Now, but rules alone cannot guarantee cooperation. Rules alone cannot guarantee cooperative behavior. There must be some ways to reinforce those rules and regulations. In other words, the rules must be backed up with threat of penalties. Backed up with threat of penalties. Then this this is complete. All right. Why do we have law? Law basically is to tell you don't do this. All right. And don't do this alone is not going to deter someone from perpetrating evil. But definitely, if you are instructed, don't do this, and if you go against this rule, if you do it, this is your punishment. That is why we have law. I don't know if we get it. There has to be what? A law that is not backed up with threat of punishment or repercussion. That is not a law. Right? What makes a law is having instructed and made it clear and obvious that these are what are requirements, and if you go, these are what are required, and if you go against this is your punishment. Then that's the body of law. So we have that. Now, law in its generic sense is a body of rules of action or conduct prescribed by controlling authority and having a binding legal force. Now look at the points. Look at the point here. We have rules and action. Don't forget, we're talking about the concept of law, rules and action, or conduct / conduct. Okay, rules / body of rules or conduct. We have by controlling authorities. All right, by controlling authority and having a binding, all right, a binding legal force. A binding legal force. Basically, it is what it is. Now, let's continue. The central purpose of the natural law is that it has a divine or supernatural origin. All right, we're talking about natural law. Okay, it has a supernatural origin. Speaking of natural law, there's a supernatural origin. It states that the validity of human laws must conform to certain objectives of moral obligation based on the natural or based on the nature of man and the dictates of the reasons. Now, basically, natural law is simply saying that for human law, for human laws, which are what we still get to understand as the class continue, it must conform. There has to be some conformity to certain, all right, to certain objectives of moral obligation based. You cannot apply law that works basically with people. Let's give an example. People that now let's say, for example, in a country whereby it's just women, no men, the law that will work there cannot be applicable in a situation whereby it's just only men in that country, no women. So any law that you are giving must be applicable. All right. Validity of human law. It says validity of human laws must confirm its nature. Must confirm human nature. All right. Any law you are making should not be outside the nature and certain obligation of mankind. That is the natural law stating that. And then now let's continue. Now, still on the concept of law, historian, all right, historian school argue that law is an outgrow from history and the society, right? An outgrow, it is an outgrow. It came out, it has ever been there, but with time, it became obvious, all right, from the history of the society, okay, rather than artificial factors. History of the society according to the historical school. So we have that as that. Now let's talk about clarification of law. All right, there are some certain classification we need to talk about. Classification. Classification. We have the private and the public law. Private and public law. We have the civil and criminal, common, civil and criminal. All right, law. We have common law. We also have customary law and non-customary. Customary and non-customary law. And in between, we also have the municipal and international law. As well, we also have the substantive law and procedural law. All these are classification. Now, when we say private law, definitely we are talking about law that regulates the conduct of person in their interpersonal dealings. All right, the dealing of one person with another, that is the private law that regulates the conduct of person in their interpersonal dealings. When we say interpersonal, anything that involves you and another person. All right, interpersonal dealings. Public handle smooth running, all right, of the mesh. This is more of we have public. This is more of the state, and we have private. This is individual. So we have that as that. Also, we have the civil law is concerned with competing private interests, all right, in our written or judge, all right. Civil law. When we say civil law now, from the word civil, we are simply talking about certain obligation that is expected of the citizens of the state. All right, what does it take to be civil? Pay your tax, okay, observe the law of the land, don't engage in robbery, don't engage in burglary, don't engage in assault. All right, all these things are being civil, okay. And basically the law that guides all this being civil is what we call the civil law. All right, and basically as we have it here, it has to do with private interest and obligations. Private interest and obligations. And in situations whereby there's a civil offense against and between two or more persons, we have someone called the plaintiff. All right, the plaintiff. The plaintiff under civil law, we have plaintiff. Sure, plaintiff. All right, and we have the defendant. When we say plaintiff, the plaintiff is the person bringing the action, while the adverse party is the defendant, the person that is being accused of a crime. All right, or a respondent. Defendant slash respondent. All right, but here, person bringing the case. All right, this is the person pressing the charges. The plaintiff is the one pressing the charges, and the defendant or the respondent is what is the one being accused of a case or of a crime. So we have that as that. Now let's continue. So customary law, these are law that emanates from custom and tradition of the people. All right, so we have that as that. And it, like I said earlier on, the customary law involves indigenous or native laws. Indigenous or native laws. Now when we say substantial, like I said earlier on, these are laws that exists. All right, these are laws. All right, these laws are defined. Substantive law now is defined. All right, the existence and extent of a right or liability in a particular branch of law. All right, this is the law that speaks more about the right and liability under the branch of law, and we have that as that. All right, and we also have something called municipal law. This kind of law is the force of law within a particular country. Municipal, force of law within a particular country. And we have international law, which is the opposite of municipal. It has to do with binding on states, regulating their mutual coexistence and relationship. That has to do with the bindings, all right, of states. Binding of states, meaning more than one state. What binds them? Regulate their mutual coexistence and relationship. That's international, all right, law as against municipal law. Now we have that as that. Now the criminal law, as we have it here, is the body of rule that the criminal law is the body of rule that defines crime. Is the body of rule that defines crime. The body of rules that define crimes. That is the criminal law. Now, a crime is a social wrong or social evil. A crime. Permit me to raise the board. It's just I want to do less of writing on the board these days and do more of explanation, so you can get the point. Okay, so we have the criminal law. Now we said that already. Now a crime is a social wrong or social evil. A crime is a social wrong slash social evil. Okay, so we have, and basically criminal crimes are punishable under the law. That we all know. They are punishable under the law or statute. Now the penal code is a collection of criminal statutes. There's something called penal code. All right, penal codes. The collection of criminal statutes of criminal, everything you can find on criminal law, on criminal statutes or statutes. Okay, so we have that as that. Now let's continue. Now the criminal law consists of three bases of ideas. The criminal law consists of three basic ideas. The first is general principle of criminal liability, definition of offenses, rules of evidence, and criminal procedure. It's based on these three things. General principles of criminal liability, what possible damage, right? Definition of its offense, and the procedure in perpetuating this offense. So we have that as that. Now let's talk about some certain terminology in crime. We have deterrent. What does it mean by, all right, deterrent? When we say deterrent, what are we talking about? Deterrence, some criminal punishment are designed from the word deterrence, stay away from something. So they say that some criminal punishment are designed to deter people. That is, to stop, discourage, or prevent a person from performing a certain act or committing crime. All right? It's just the punishment that tells you that, okay, if you do this, you get this. So it tells people to stay away from committing this crime. To stop, to discourage certain acts. Okay, now we also have what we call rehabilitation. Rehabilitation, in theory, the benefits of criminal laws include offering of education, counseling, training, and treatment. It is a process of helping a person to attain or regain his potential as a citizen. Rehabilitation. Okay, the concept is just to help, like giving inmates counseling and words of encouragement so that they can become, attain or regain their potentials. That's more of a place whereby you take prisoners to, all right, or anybody in custody in order to help them get some counseling, recreation, and everything, just to make sure they regain their potential self. So we have retribution, takes place when society, through criminal justice system, takes revenge on other offenders. Retribution is all about revenge. Retribution. It's all about revenge. One party revenging on the other party. And then we have that as that. Now let's continue. Now you also have to understand the term. You also have to understand the term punishment. All right. In every society, delinquent behavior fascinates many people. That is very certain. The society becomes anxious on those people who are caught and are dealt with. In 1970, after Nigeria Biafra War, there was an ever increased rate of crime. This prompted the government to introduce capital punishment. All right, capital punishment, and basically, this is when citizens perpetrate a crime, and they have to face the wrath of the law. And we have that as that. Also, we also have something called correctional models. Now, Correctional models come in place after the juvenile has been disposed in the courts. Right? Delinquent offenders are placed in some form of correctional treatment. Let's not forget we said delinquent is a crime performed or perpetrated by a minority or underaged. All right, that is what we refer to as delinquent. So correction model is more of that's a correlational correctional model. Okay, it's more like a place whereby as soon as an offender, a delinquent offender, is disposed at the court, they are being brought here. Now we have what we call restorative justice. When we say restorative justice, what are we talking about? Restorative justice is a policy based on restoring the damage caused by crime and create a system of justice that include all parties harmed by criminal act. That is like the name says, restorative justice. All right, restorative. Basically, it's unfortunate. When you only get to restore when there has been a loss, right? So it's quite unfortunate. You have to wait before there's a loss before you can restore. So we have that as that. And lastly for today, so we have criminal proceedings. Generally is either a process by which a criminal case is prosecuted or the body of laws and rules regulating the administration of the criminal law. Like we said earlier on, the proceedings. It's either speaking of the process on how a particular case is being handled or laws that regulate the act. The Criminal Code section 218 Criminal Code under section 218. Awesome, someone just smashed the like button, that's good. Okay, Criminal Code section under Criminal Code section Criminal Code section 218, 221 and 222 cap 77 laws of the Federation of Nigeria make it an offense to defile a girl. Makes it an offense 221 and 227 and 222 cap 77 cap 77 makes it difficult, makes it what? A crime, an offense in the law of the Federation of Nigeria in 1990. All right, offense to defile a girl. Okay, offense to defile a girl. The foul here is more of like rape. You forcefully have sex with somebody. Basically, we have that as that. We've been able to cover a lot of things, and basically, we have actually gone far, and we have been able to conclude with the course CSS221 on the familiarization stage. All right. So for those of us who are a member of the private class, The next time we're coming back to this class is going to be on Telegram, where we get to discuss what you've been able to hold on to during the formalization stage, which is what we are doing. Thank you very much, everyone. Let's go to submit our notes to our respective classes. And for those of us who might be wondering what is a private class all about, do well to reach out to me to get more information. Looking forward to seeing you all in subsequent tutorials. Bye bye.